Good morning, everyone, and welcome to our 16th annual seminar, and very well-attended event today. I assume everyone's just sick of what's going on in Washington, whatever side you're on, and I'm glad you guys are here. We have a very ambitious agenda today, and you're going to see some new faces. We've hired a number of workers' compensation lawyers, and many that are seasoned workers' comp lawyers. So hopefully it's going to be informative, a little bit of entertaining, but mostly informative. And at this point, I want to turn it over to our workers' compensation head, Burke McLemore, who is probably the only attorney here who's done it longer than me, as you can see. So I'm going to turn it over to Burke, and welcome. Hope you enjoy it.
Thanks, Ed. When I started doing this 41 years ago, I was as tall as Ed, and I've been beaten down over the years. I think we should all give a round of applause for Mr. Jordan, who on Monday will be celebrating 38 years at Thomas & Hafer. Ed started with us when we were using quill pens, and in any event, as Ed pointed out, we have a very ambitious agenda today, and we have a topic which I think you'll find extremely informative and important, not only in your professional lives, but in the lives of your family and friends. And so without further ado, I'm going to turn it over to Mr. McHugh.
Good morning, everyone. One of the people in the case law come up, and then I'll do some housekeeping. As you, upon entering, you saw the refreshments there. We have to have 3 breaks as required by the accrediting organization. Every year I say, we really have to have 3 breaks. So they will try to come back around these players. This first break will be additional revenues over there, and next week is some other things in the other line. So the first group is going to go through a series of cases, and then we'll go through the first break.
Morning, everybody. I'm Jim Tinio, and I work in the Harrisburg office of Thomas & Hafer, and I'm here to facilitate a discussion about the Pennsylvania cases that we're going to be analyzing and sharing with you. And our chair has just reminded me that if folks can put their phones on vibrate so we don't have any untoward interruptions during the discussion, that would be great. I think we've chosen a very interesting mix of cases for you to hear about, and we've got a collection of our very experienced and skilled lawyers from across our 5 offices in Pennsylvania, including Mark Allen, who handles workers' comp in our Allentown office, Mark Powell, my partner in our Harrisburg office, Sean Epstein from Pittsburgh, Ryan Blazier from Wilkes-Barre, young Justin Beck, also from Pittsburgh, and young Deborah Richmond from Philadelphia, and very young Katie Bavosa from Harrisburg. So without further ado, let's kick it off and let's talk about some of these interesting cases. And I think Mark Powell has the first case that we're going to be discussing, and it's the LifeQuest case. Mark, can you tell us a little bit about it?
Yes, the LifeQuest case is a case that deals with issues pertaining to a notice of temporary compensation payable. I believe this is the 2nd year straight where I've addressed notices of temporary compensation payable with you, and that tells me 2 things. 1, you are continuing to use temporary notices of compensation payable, and 2, claimants' attorneys are continuing to challenge the use of notices of temporary compensation payable.
Try to keep me around.
Press and hold mute to turn on.
Okay, maybe this is better. As everyone knows, the NTCP is a valuable tool to help control or mitigate claim exposure when properly used. In the LifeQuest case, I'll run down the facts for you quickly. The claimant sustained an alleged work injury. An NTCP, or Notice of Temporary Compensation Payable, was issued. During the period, the 90-day window within which temporary compensation was payable, the claimant returned to work in a modified duty capacity. In order to effectuate a change in benefit status from total disability to partial when the claimant was returning to modified duty work, the employer filed 2 supplemental agreements with the Bureau of Workers' Compensation. They were executed by both the claimant as well as the employer. At the end of the 90-day window during which temporary compensation was payable, the employer decided not to accept liability for the case, issued a notice stopping temporary compensation payable, and a notice of workers' compensation denial. As is typically the case, a claim and penalty petition was filed. The penalty petition alleged improper use of Bureau documents and suggested that the employer's decision to file supplemental agreements during the window within which temporary compensation was payable constituted a formal acceptance of the case. The workers' compensation judge granted the claim petition, terminated the claimant's benefits, and denied the penalty petition. The claimant appealed the matter to the Workers' Compensation Appeal Board, which reversed and found that the employer's use of the supplemental agreements was an improper use of the documents, which constituted a formal acknowledgement of the case. After some remands going back up to the board, the matter finally made its way to the Commonwealth Court. The board had determined that the employer's use of the supplemental agreements served as an acknowledgement of the case, and therefore it could no longer be denied once those documents were issued. The Commonwealth Court reversed that decision from the Workers' Compensation Appeal Board and held that the issuance of the supplemental agreements did not constitute an acceptance of the case. In reaching its conclusion, the court noted that there was a conflict between its prior case in Guy Rees and Section 121.7 of the regulations, which was opposed to Guy Rees' amendment. In the Guy Rees case, the Commonwealth Court had previously held that once you issue a notice of temporary compensation payable, you are bound to continue paying the claimant at the rate that was set forth in that notice, notwithstanding the fact that claimant returns to work and is earning wages. After the Guy Rees case was rendered, the Bureau promulgated regulations which provided a remedy to employers. Regulation 121.7 essentially indicated that to modify a notice of temporary compensation payable during the window within which temporary compensation is payable, you simply have to issue an amended notice of temporary compensation payable. You could change the rate reflected in the temp notice through issuance of the amended notice. The court in LifeQuest noted that the employer's use of a supplemental agreement was a good faith attempt to address the issues that were raised in its prior Guy Rees decision. As such, the court did not feel that what the employer did constituted a formal acceptance of the claim, but really was nothing more than providing additional Bureau documents to effectuate a change in the claimant's rate at which compensation was being paid. In essence, it was simply a benefit status change as opposed to any document formally acknowledging the case. As a result, the court held that the documents issued by the employer did not constitute an acceptance of the claim, and the decision of the Workers' Compensation Appeal Board was reversed. The takeaway you can look at from this case is be careful when you're using your notices of temporary compensation payable. The claimant's attorneys are always trying to find a way to argue that you've improperly used the document, because the consequence of improperly using the document is that you have accepted the case. Here, the court found that the supplemental agreements were not used improperly, which obviously was a good thing for the employer. However, it did suggest that the preferred method to show a rate change during the period within which temporary compensation payable is through what's set forth in the regulations, that being the amended temp notice. So keep that in mind when you're moving forward so that you can eliminate some of these arguments in protracted litigation. This was a 2014 injury, and we just received a decision from the Commonwealth Court in 2018 showing the sort of the litigation that can result from these types of issues.
So Mark, I know a lot of claims folks out there, in lieu of supplemental agreements, like to file notifications of suspensions or modifications. And if, let's say, the claims person had done that in this case during the period that temporary benefits were being paid under a TNCP, do you think the outcome would have been any different?
I don't think the outcome would have been different. I question whether EDI and WICAS would have actually permitted you to file a notification of modification or suspension during that 90-day window. But if WICAS and EDI did permit that to occur, I don't think the result would have changed, because a notification of modification or suspension essentially is a unilateral method through which you can change benefit status, as opposed to a supplemental agreement, which is something that a claimant signs as well. They're two documents that do the same thing, that just have some different timeframes within which you can use them.
Ah, yes, the all-knowing and all-powerful WICAS. Let's move on to the next case, and we've got the other Mark, our young gentleman from Allentown, to discuss the Armour Pharmacy case and the impact of fee review in connection with a compromise and release. Mark, what can you tell us about Armour Pharmacy?
So this is it's an interesting case because it has to do with a subject that all of you like, payment of compound claims. And in this case, just to give you some background, the claimant was injured in 1999. The next year he settled his wage loss. So that's the year 2000. Fast forward 15 years, employer's still paying medical bills. In the year 2015, compound creams were prescribed and dispensed. At that time, the employer filed a request for utilization review. The determination came down that the compound creams were in fact reasonable and necessary. Employer did not challenge. The next year, they were dispensed again. This time, the employer just refused to pay. And in this case, a fee review was filed by the provider, which is Armour Pharmacy, because they dispensed the compound creams. The determination came down that about $7,000 was owed to the pharmacy. In this case, the employer did file an appeal or a challenge to the fee review. So it went in front of a fee review officer. Now, in the interim, what they did was negotiate with the claimant and execute a compromise and release agreement, settling the medical portion of the claim as well. This is in 2016. But what they did is specifically indicate that the medical bills would be paid through the compromise and release hearing date, but they specifically excluded those compound creams. The problem with that is that the determination already indicated they were owed to this Armour Pharmacy, the provider. So the compromise and release agreement gets approved, and the employer walks in with the compromise and release agreement and submits it to the fee review hearing, at the fee review hearing to the officer. They argue that this was compromise and release and they're not obligated to pay these bills. At that point, the provider has counsel and they're arguing due process because they were never a party to this compromise and release agreement. There were jurisdictional issues raised. Ultimately, it went up on appeal, and the Commonwealth Court eventually held that the compromise and release agreement cannot be used to exclude the pharmacy bills. So due to the fee review determination and the prior utilization review determination, those are the procedures under the Act to challenge those bills. Since it was already determined that those bills were in fact payable to the pharmacy, the compromise and release agreement could not be used to exclude that the provider's bills. And the reason for that is because they were not a party to the contract, they were never given notice, they were never negotiated with, they never agreed to compromise their bills. So when handling cases, I mean, the takeaway for us as defense counsel and when you're handling a claim is you really cannot just ignore a bill if it's out there, if there's a determination, if there's a fee review. So it could be a case where you're settling the case, whether it's wage loss and medical or just the medical, but if there's a pending fee review or utilization review determination, or there's one already in place, you can't just ignore that litigation. So that has to be contemplated. And there's a few ways to contemplate it. The first way is so if you look at the timing of this, they negotiated settlement with the claimant during the pendency of the fee review. So that was contemplated. So the adjuster or the representative and the attorney should, when you're actually determining settlement exposure and making an offer, negotiating, that should be contemplated. And it must be addressed. So either the claimant has to pay out of the lump sum, or even better yet, you would pay out of the lump sum and satisfy the provider's bill. But that's a part of that negotiation process. But it has to be specifically addressed in the compromising release agreement. You can't assume that the CNR is going to just, it's not going to set aside any fee review determination or UR determination. Another way to do it, and it wasn't done in this case, but initially in 2015, when you, especially with compound creams, if you have a utilization review determination, and it's usually the best thing to do is get an IME at the same time so that you could challenge that determination. That determination was never challenged initially. And I could tell you in our jurisdiction in the Lehigh Valley area, if you get a case, a compound cream case in front of a judge, depending on the facts and the injury, there's a good chance that you would be successful if you have a good opinion. But that's another way to challenge it initially as well. But when you're negotiating the case, you definitely want to account for those bills.
Thank you, Mark. I'm going to move on to Justin at this point, and Justin's actually going to tackle two cases for you. One dealing with the coming and going rule, and another one dealing with the sufficiency of the job offer. So, Justin, please educate us.
Thanks, Jim. So the first case I want to talk about is Push VWCAD Power Contracting. The key issue in this case is the coming and going rule, which we're all pretty familiar with. Here, the claimant was an electrical worker. He was driving from his home to an assigned job site when he struck a patch of ice and caused a vehicular accident, and he was injured. Now, the claim was denied on the basis that the injury occurred while the claimant was en route to work and falling within the coming and going rule. The claimant argued that he was a traveling employee, so his travel should be included in the course of employment. He testified that on a typical day, he drove directly from his home to whichever job site he was assigned to at that time. And these assignments would change frequently, and they were always temporary. Now, he did acknowledge that he was only compensated for travel time when his commute involved stopping along the way to the job site and picking up equipment that would be used for the job that day. Ultimately, the Commonwealth Court held that he was not a traveling employee. Though he did change job sites pretty frequently, they emphasized that the mere fact that the job is a discrete and limited duration does not render an employee without a fixed place of work. This was still a fixed place of work. In this case, the claimant's credited testimony showed that he only anticipated working at that singular job site on the date of injury. And in fact, he had worked at that job site for a few weeks even prior to. The court also dismissed the claimant's attempted argument that his employment contract had included travel. While he was occasionally provided travel allowance, he had not established that that allowance was related to the actual expense and time involved in commuting. So the couple takeaways from this case is that a traveling employee who's injured while traveling will be covered. That's the general rule. We know that under the coming and going, when they are a traveling employee as an exception to the coming and going rule. However, employees with a fixed job site, even if that's a limited duration and it changes pretty frequently, that's unlikely to be considered a traveling employee. The travel will fall within the coming and going rule. And that's even if the particular job site is not the headquarters of the company or a permanent assignment. That does not matter. And finally, the travel inclusion exception to the coming and going rule will not apply unless expenses relate directly to the travel in question. And that's the Push case.
Yeah, I mean, those types of cases are very, very fact-specific, and as Justin said, and it bears repeating for emphasis, just because the employee is not driving back and forth to headquarters, they can have a different fixed place of employment, even if it's temporary, and that makes them not a traveling employee. And remember that if you're a traveling employee and you're injured, you're pretty much covered by comp unless there's some major deviation from your work duties. So that's an important inquiry, is whether that person was going to a fixed place of employment, not necessarily headquarters for a specified period of time. Thanks, Justin.
Sure. Now, the second case we have is Nahas WCAB Synergistic Partners. The whole key issue here is sufficiency of a specific job offer. And I will note at the outset that this is a memorandum opinion, so it is not binding precedent, although it is persuasive. And we're finding more and more that workers' comp judges and the appeal board are persuaded, and they're citing these unreported opinions. So it's still important to know. Here the claimant was a warehouse receiver and printer. He sustained an injury, and that was acknowledged by a notice of compensation payable. 4 years later, and after an entire initial round of litigation, the employer filed a petition to suspend, and they alleged the claimant had refused work within his restrictions. Now, the job that was offered to him was actually 40 miles from the claimant's home and prior job site. However, at the hearing, during the litigation, at a particular hearing, the HR coordinator for the employer, he testified that the same position had become available at the claimant's original job site near his home. And he further testified that the facility was on a public bus line, making it accessible, and the coordinator even indicated that the employer would pick him up from the bus stop if he required that. Now, historically, Commonwealth Court has not held that these kinds of travel accommodations are not required, so please don't think you have to start sending limousines or anything to claimants' homes. That is not the case. Now, the Commonwealth Court held that the testimony of this HR coordinator constituted a sufficient job offer for a full-time sedentary position. And the court said that you don't actually have to provide that job offer in writing, though it is still the most prudent thing to do. And the court also stated that while this position, it's only considered available through means of transportation, the employer had demonstrated that the claimant could commute to the position. So the takeaways from this case are that, again, unreported, not binding, but persuasive. The transportation being provided by an employer to show work availability is actually contrary to established precedent. You don't have to prove the existence of that transportation. And most importantly, things happen. In the course of litigation, you forget to provide a written job offer to a claimant. And this case tells us that that's okay. If there is still testimony indicating specifics about a job offer, that's sufficient. And as long as that oral job offer meets the legal requirements, conveying sufficient details about the position, you have still conveyed a specific job offer despite the fact you did not send it in a formal written memorandum.
Thanks, Justin. You would still, again, urge our folks to send out written job offers because that's the most safe way of establishing that there's a legitimate available job.
It would avoid having to use this case and try to persuade the judge, yes.
And if something slips through the crack, we can still clean it up in employer testimony.
You can still clean it up with evidence.
Great. Ryan, you're going to be talking about mental injuries.
That's right. And oddly enough, sorry, I'm loud. Oddly enough, Jim did not pronounce the name of the case, which we'll get to. However, we're asked to present, sometimes we volunteer to present, and yet I present this year, I presented last year, but for some reason there's a roll of duct tape right in front of where I'm sitting. So I don't know if that's an indication as to when I start going on about those darn pesky penguins or something that Sean's gonna have to put some tape over.
Right over his mouth.
But anyway, as some of you will recall last year, the case I discussed was called Poliskevich. This is called Frankevich. If anyone is not from northeastern Pennsylvania, we drop the W, make it a V, and then just make up the rest. So if you take nothing away, you can learn how to pronounce some of the names up in the northeastern Pennsylvania region. But, and also apropos for my presentation style, I've been asked to present on mental cases. So what are we dealing with in the Frankevich case? Well, Mr. Frankevich was a chemical operator who surprisingly then complained of chemical exposure. That sounds like an ordinary workers' compensation case in the course and scope of our employment. So he makes this claim, he makes basically what had been started off as a physical mental injury. And as you probably are aware, and we deal with these that often because usually it's ouch, my neck hurts, that kind of thing. But we have mental cases, we have physical mental cases, and we have mental physical cases. And the burden of proof for each is a little different. Now, in this case, Mr. Frankevich wanted to prove a physical mental case, which is a much easier burden. I got an ouchie and now my head hurts inside. Now that's, we usually use psychologists and neurologists to use much more fancy terms than that, but it's not much more than that. So, however, Mr. Frankevich, though, the interesting part of his case was that he made his way to the emergency room, and that was pretty much it. By the time he left the emergency room in about an hour's time or so, he was better. And again, practicing Northeastern Pennsylvania, and those of you who do have never heard of this, but the judge actually said, well, that really wasn't a whole heck of a lot of treatment. And that's why I have the bullet point there for transient symptoms. Amazingly, despite the fact that he did treat in the emergency room for what he did perceive as physical injuries, the judge says that wasn't enough. So what the judge in this case did, what WCJ did, was he applied then the mental standard, which means that in order for somebody to have a mental stimulus causing a mental injury, what they have to prove is abnormal working conditions. Well, one of the first things I said, aside from some corny dad jokes, was the fact that Mr. Frankevich was a chemical operator who was chemically exposed. It's not exactly abnormal working conditions. So that was the issue that the WCAB and ultimately the Commonwealth Court were tasked with dealing with, was did the WCJ apply the proper standard in removing it from a physical mental case to a mental case. And ultimately the court did determine that the judge had done that appropriately. Now, one of the other very interesting things about this case, which doesn't happen too often, was the fact that the judge below had actually assigned his own independent medical examiner to take a look at Mr. Frankevich and determine whether, basically what the heck was wrong with this guy. And interestingly enough, and I think this probably guided a lot of where the judge went with the case, was that this was a Dr. Greenberg. He identified that the most likely diagnosis for all of Mr. Frankevich's symptoms was anxiety, depression in the context of symptom magnification and obstructive sleep apnea. So I think this was ultimately a practical case clothed in some very technical legal terms, but I think the case was certainly rightfully decided, and it gives you hope, because when somebody, and I'm sure you've seen this before, when you have a physical mental case, they're usually hard to fight. They'll find some physical stimulus or some physical injury that they can point to try to get those benefits. But this case does give us hope that if that's only, I went to the emergency room and got checked out, was put under observation, then left, that's not enough. And it can arguably be a transient symptom leading to it.
So, just to review the three different types of injuries. Sure. Physical mental means there's some sort of physical stimulus that results in some sort of mental issue or disability.
That's correct.
And then mental physical means that there's some sort of mental stress that leads to some sort of physical injury or disability. For instance, like stress at work causing a heart attack.
Right.
And then mental is just pure mental stress leading to mental disability.
Right. And of course the touchstone is abnormal working conditions, and here that was simply not the case.
And that's purely for mental, that latter category. That's the higher standard that's applied. It's not applied to the other two types of conditions.
Absolutely, and some of you may recall our prior discussions on that very issue years ago when there was a new case that had come down from the Supreme Court about the police officer who had witnessed a suicide by cop. The standard for mental has, and the abnormal working conditions, has watered down a little bit, but it's still there. You still have to prove those abnormal working conditions.
Yeah, you referencing that case, and it's a really bad case. It's a Supreme Court case that basically changes it from a reasonable person standard in terms of what is abnormal to a subjective standard in terms of that person never having been exposed, even if it was a police officer who's trying to revive somebody who jumped out in front of his car. If he had never done that before, that's not considered an abnormal working condition based on that Supreme Court case, which is, I think, wrongly decided, and hopefully, there'll be some blowback, and some of the other cases coming down will water it down a little bit.
And they didn't use the duct tape.
So next up is my partner from Pittsburgh, Sean Epstein, and he's going to be quite apropos talking about the intoxication defense, since that's one of the sort of the theme of today's presentation.
Exactly, we're going to be talking about intoxication today. Just had to throw that out there. It's one of my favorite shots from John Belushi in Animal House. But as Jim said, intoxication is a big issue these days because of the big issues regarding medical marijuana and the opiate issues. So I thought, while the Cooley case doesn't necessarily break any new ground in terms of the law, I think it was important to talk about the burdens of proof and things you need to do to establish an intoxication defense. The first thing you want to look at is the law itself. It's a really short part of the statute. It says, no compensation shall be paid if the injury would not have occurred but for the employer's intoxication. So you got to prove two things. You got to prove that the person was intoxicated, and you got to prove that basically, but for the intoxication, the injury wouldn't occur. So let's look at the facts of the Cooley case, which are kind of fun. The claimant was employed as a disc jockey. He had, after his shift ended, gotten into an altercation with some of the bouncers. Generally not a good idea. Bouncers are generally big. They're bigger than Ryan here. The claimant had some injuries. There was some conflicting testimony about how he was injured. Did he slip on a wet floor? Did the bouncers beat the heck out of him? The case was litigated, having spoken to the judge about this case, for almost 2 years with many, many witnesses. He filed a claim petition seeking entitlement to benefits. And the employer filed an answer denying the affairments and raising the intoxication defense. So that's the first takeaway. Intoxication is an affirmative defense. You have to establish and you have to plead it. If you don't raise it, the judge isn't going to do it on his own. So if you have suspicions that someone was intoxicated and that this was the cause of their injury, you need to let your counsel know and provide them with the information so that can be pled right away as part of the defense in the case. The testimony was interesting. The claimant testified that he had, over the course of his 4-hour shift, 3 to 4 Jack and Cokes. There was a tremendous amount of testimony as to how much booze was put in those Jack and Cokes. But there was no question he was drinking. Even the owner testified that he witnessed the bartenders pouring double shots, but that the claimant didn't appear overly intoxicated. But there was a number of witnesses who said that there was only 1 shot in it, there were 2 shots in it, he was stumbling drunk, he wasn't drunk at all. The judge concluded that the credible testimony established the claimant was significantly intoxicated and that this caused the injury. Okay, well then benefits should be denied, right? It was proven that he was intoxicated, and it was proven that that intoxication caused the injury. I don't know if many of you are familiar with Judge Benedict in the western part of the state, but he has a tendency to come up with his own solutions based upon the facts. He did that here. He said because basically the employer provided the fuel, allowed the claimant to drink, that they were the cause of the incident and denied benefits in the case. Pretty creative, I have to admit, in this case. The board reversed. The board said, no, you can get your employees as drunk as you want, but if that drunkenness caused the work injury, then they're not entitled to benefits. So the board followed essentially the letter of the law. The Commonwealth Court vacated the order of the board. They said, as we've indicated, that intoxication is an affirmative defense. You have to plead it. You have to establish all the elements. You have to show that the person was intoxicated and that but for the intoxication, the injury would not have occurred. And what they did is they then went on to define what intoxication means. And this is a second point that I think a good takeaway is. They said that means to be overwhelmed or overpowered by alcohol or liquor to the point of losing his or her faculties or sensibilities. They went on to state that you don't need necessarily a blood alcohol test. You don't need a breathalyzer. But you need evidence, and it can be done via testimony, to establish what is intoxication. So again, another takeaway is, if you have this type of case and you suspect that intoxication might be involved, you're going to want to talk to all the witnesses, all the people who were there, get statements, have an investigator early on to track down all this information. And that's especially true if you don't have blood alcohol testing or breathalyzer testing. So what the court did is they said the judge made no findings on how he arrived at his determination that the claimant was intoxicated, and he made no findings as to whether the intoxication was the but-for cause of the injury. I think actually the judge did in my reading of the decision, but the Commonwealth Court disagreed, and they remanded it. On remand, it's not in the slides and it's not in the decision, obviously, but what the judge just said is, I don't find him intoxicated. You want to award this guy benefits. I want to award this guy benefits. I'm not going to countenance the employer for doing what they did. He just went and said, okay, fine. He's not intoxicated. So the takeaways from this case. Intoxication is an affirmative defense. So as your attorneys, we have to plead that in our answers. So we need to know all that information. 2, it's not enough to just be intoxicated. If you're intoxicated and a brick falls on your head and causes tremendous injuries, I don't know that the intoxication was necessarily the cause of your work injury. So intoxication alone is not going to be enough. 3rd, and I think a big thing to talk about today, is it doesn't have to be alcohol. It can be other substances. It can be other drugs, marijuana, opiates, anything that could meet the definition of intoxication that we talked about. And I think the final takeaway of this, the real big important takeaway is, if you're drinking, don't mess with the bus.
One of the questions I had, this more practical, I guess, approach for our clients is, if you, let's say the takeaway you're telling me is that even if you don't have those wonderful studies that show, 0.08 or above of alcohol or drug presence, you can defend the case if you've got basically eyewitness accounts of the person's behavior. But let's say you do have the lab study results and you can use them. What do you do with that? Do you get somebody to give an opinion about it, or what do you do with that type of evidence?
Well, I think what you would want to do is, if you, for example, have blood alcohol breathalyzer or blood alcohol testing that shows the person will be over what we consider the legal limit, I think you would want to offer that. And I also think you would want to offer, if you don't have that, testimony from people that says this person was maybe staggering around drunk, or you have an expert. If it's a big case, you would have an expert, a toxicology expert, to say, hey, based upon this blood alcohol level, the amount of alcohol that this person had in their blood, this definitely caused their accident. So you can develop expert opinions, but it's not necessary. The judge is going to be the one who ultimately makes that finding based upon the totality of the evidence that's presented.
Thank you. Next up, we have Deborah, who's going to be talking, I guess, about 2 cases sort of together that deal with labor market surveys.
Good morning. There we go. Is it on now?
You want to switch mics with somebody?
No.
Oh, thank you. My technical issues. Good morning, everyone. So I'm going to be talking about labor market surveys in the era of Phoenixville. There was a lot of question following Phoenixville when this case came out, Phoenixville versus WCAB showed whether this was going to be a good thing for employers, a bad thing for employers, but I think overall it has turned out to be a good thing for employers. In Valenta and Smith, you essentially have the 2 different cases with a lot of the same facts. You had work-related injuries in both cases. You had employers' medical experts indicating that there were some restrictions to a return to work. There was not a full recovery opinion. So in both cases, the employer stopped the labor market surveys. You had your medical experts testify. In Valenta, you had vocational counselors on both sides. Claimant testified that she could not possibly perform any of the positions physically. Her counselor said she was not able to perform any of the positions in terms of her skills. The judge didn't find any of that to be credible. She went ahead and attempted to apply for all 6 jobs that were presented in the labor market survey. To varying degrees of success. She went ahead and to this one she submitted an application, to that one she put in a phone call but never got a phone call back, on and on. And her argument was, well, because I didn't get any of those jobs, none of them were open and available. Well, in that case, the judge disagreed and actually looked at her testimony concerning what steps she went through, the fact that she put in an application. The judge also looked at things like if she got an interview and said simply because you didn't get the job, that doesn't mean that position was not open and available. Obviously, if you got an interview, if you were able to put in an application, those jobs were open and available. Therefore, the WCJ granted the modification petition based on the labor market survey, and her benefits were modified. The Commonwealth Court agreed. In Smith, you had a very similar history. He interviewed for 2 of the 5 positions that the vocational counselor found. He spent a lot less money, actually, than the claimant's counsel in Valenta, because he didn't have a vocational expert. He didn't have, although he had medical testimony, or he had a medical report, he didn't have medical testimony. But regardless of the amount of money, he essentially had the same results. He testified that he applied for all 5 positions, he got 2 interviews, didn't get any of the jobs, and he said, therefore, not open and available for purposes of a modification petition. And again, the judge did find him credible in this particular case and said, I believe you genuinely applied for these jobs. I believe you tried your best, you showed a good faith effort. However, the labor market survey and the fact that you got 2 interviews indicates that those jobs were in fact open and available under Phoenixville Hospital. Phoenixville stands for the proposition that the jobs to be open and available, and that testimony, the claimant be allowed to provide testimony, present testimony as to their attempts, good faith efforts at applying for those jobs. But the court has now determined that while that testimony is relevant, it is not dispositive as to whether those jobs are open and available. Now, the issues in these cases, even though, this was a good result for the employers. They got their modifications, even though the modification was modified slightly in the Smith case. The court determined, the Commonwealth Court said, you can't base the labor market survey on all 5 positions because he only got interviews for 2. And therefore, they increased his weekly benefit rate by $7.67 a week. So maybe he won the battle but lost the war there. He got his, approximately $8 increase. However, the problem that we're seeing here is that the information that the jobs were open and available, that is employer's burden of proof. In these cases, it was the claimants that provided that information, that that job was open and available. So what is a savvy claimant's attorney going to do? They are going to tell their clients, do not provide that information. Do not present any evidence that you applied for those jobs, that you were able to put in an application, that you got an interview. Do nothing. That in itself could be a problem with some judges. That doesn't show a good faith effort. However, you never want to be in a position where you're depending upon the claimant's testimony in order to prove your case. So the solution here, I think, the takeaway, is to have a very good vocational counselor. You want to have a vocational counselor that is going to be on it. You want them to get their all the materials out quickly. You want them to set up that labor market survey. You want them to email the positions to the claimant. The claimant should provide their email address in the vocational interview. And you want them to follow up and make sure that those positions remain available following the interview with the claimant.
Thank you, Deborah. I know that when Phoenixville came out a few years ago, a lot of us who handled labor market surveys were concerned about whether it was harking back to the pre-labor market survey days of Kaczynski, which, as many of you may know, required the employer to actually find a job, and the claimant had to get the job. If the claimant, let's take the same facts as what Deborah's talked about in these 2 cases, if the claimant got an interview and didn't get the job, absent some sort of sabotage evidence or bad faith on the part of the claimant, benefits continued. So I guess one of the big takeaways from these two cases is that labor market surveys are still alive and well in the aftermath of Phoenixville. Is that right?
That's correct.
Well, that's good to know, particularly since we don't have the other cost reduction measure available anymore, IREs, at least not at the current time. So we've got labor market surveys, and one other thought occurred to me is that the vocational expert who's doing the labor market survey, and you tell me if you disagree with this, should probably work it up as though it's a Kaczynski case. In other words, identify the jobs, get the job offers out, or the job identifications out to the employer, the employee, or the claimant's lawyer as soon as possible via email, as you indicated. And really, and this is something that Mark Powell did a few years ago, I still remember this, the case started out as a labor market survey. And there were some issues with the sufficiency of the labor market survey. So Mark quite ingeniously turned it into a Kaczynski case. And because the claimant didn't follow up on the jobs, as Deborah suggested, some sharp claimants lawyers may advise their clients not to do, we were able to get a modification of benefits based on traditional Kaczynski. So I think the other takeaway is that both Kaczynski and labor market surveys are still available tools to us. And quite frankly, if the courts are going to blur the distinction between the two of them, let's blur the distinction to our advantage when we have the chance. Last but not least, we have Katie Bavoso, and she's going to talk about the Construction Worker Misclassification Act. Whatever that is, Katie, so educate us about that.
Thank you. I'm talking about a Supreme Court case that came out this summer, approximately the end of June. It was called Department of Labor and Industry versus the Workers' Compensation Appeal Board, Lynn and Eastern Taste. First and foremost, to be successful on a claim petition, a claimant needs to prove that they are an employee. And if they can't do that, a lot of times benefits obviously are denied. Employers try to argue in a lot of cases, they're not my employee, they're an independent contractor. So in the past, we have gone through the multifactorial process of determining whether someone's an independent contractor or an employee with you in the various cases that have come out. We've told you to look at who has control, who has responsibility, the terms of the agreement, the nature of the work, the skill required, which party supplied the tools, were they wearing uniforms, that type of stuff. That then progressed, and a few years ago, we sat before you and told you that the legislature was getting annoyed with certain industries that were trying to get away with not purchasing workers' comp insurance and deeming all their quote-unquote employees as independent contractors. And one of those industries was the construction industry. So we ended up with, as Jim said, the CWMA. That's what I'm going to call it because it's too long otherwise. Obviously, in the Construction Workplace Misclassification Act, certain things were set forth to prove whether someone was in fact an employee of the construction industry or whether they were an independent contractor. The problem, however, because there's always problems with these acts when they come out, is although it may have seemed logical, they failed to define the term construction industry. And because they failed to define the term construction industry, a lot of construction industry type places were trying to pull loopholes and say, well, we're not really in the construction industry. So that brought about a new round of cases before the judge with employers saying, this CWMA doesn't apply to us. That brings us to this case. This case is against a restaurant called Eastern Taste. And Lynn was the claimant. He was a guy with some remodeling experience, and his sister-in-law was opening this restaurant called Eastern Taste. So you see where I'm going with this. The sister-in-law had a conversation with Lynn and asked him to come in and do some remodeling work before the restaurant even opened. Unfortunately, he fell off a high beam and he was rendered a paraplegic. He sued his sister-in-law saying, well, now you have to use your workers' comp and pay for the rest of my life, all of my medical and wage loss. Of course, she had no workers' comp, right? So the UEGF got involved And a lot of these cases with the CWMA or an argument as to whether someone's an employee or an independent contractor do involve the UEGF, which is, the organization in the state that comes and defends employers that have purchased no workers' comp insurance. And a lot of times, maybe they've purchased it, but not for that person because it's not their employee, or not with that type of thought in mind. In any event, this restaurant wasn't open, and she said, he wasn't my employee. He's an independent contractor. The judge agreed, and the board agreed, or the board reversed and said he was an employee. And then it went all the way up to the Supreme Court. And the Supreme Court said at first they were just arguing whether he was an employee or not an employee. We have to look at the other facet of this as to whether or not he applies under the CWMA. He was arguing that even though this was a restaurant involved, that it wasn't open at the time. And the duties that he was performing were construction in nature. He was remodeling. So based upon that, he thought that the restaurant fell under the CWMA. This was a case of first impression. So the Supreme Court went through a lengthy statutory interpretation as to what, construction industry actually meant. And they decided it's not what the person was doing when they were hurt. It didn't matter that he was doing construction type activities, that you really need to look at the employer and the nature of the employer's business. And as such, they found that the CWMA was not applicable to a restaurant. I mean, that seems very logical to all of us, but it took a 43-page opinion from the Supreme Court to state that. And basically what they said that they wanted to avoid was any plumber or, decking guy or electrician that comes into your house and has an injury saying, well, because I was doing construction type services at your home, you are now a person within the construction industry to which this act would apply. So the court basically defined it now as various places that actually do just construction and not just have people come in doing construction activities on occasion. So that was the takeaway. It's one of those things that we don't see very often. I would say in the last 7 years or so since the CWMA has been in existence, I've only seen one case where it was actually brought up at all. But it's something to keep in mind.
Thank you, Katie. Gene, I think do you want to allow some time for questions if there are any, or do you want to?
Yeah, one or two, I can fill in some other things too, though.
All right. Are there any questions about any of the cases or issues that we discussed for the faculty? Feel free to chime in or raise your hand if there are. Okay. Well, thank you very much.
We will start our break in a minute, but since things are quiet and everyone that's coming is probably here, I want to introduce some other folks who are present and who from TTNH and working in this field every day. We have fewer speakers in-house this year because the next two programs will be medically related, and Burke will moderate both of those since he's been working with the speakers in organizing and their presentations. From the Harrisburg office, present but not speaking this year is Randy Gale. I know Randy is Randy's still here today. He'll be doing some actual work today. So Randy's here. One of our paralegal who's now shifted to the workers' compensation world, and she's really thankful about it. She is, every day she wakes up and says, this is fascinating. Denise DiMatteo, and Denise will stand up and wave for 2 seconds. Thank you. Coming from the Lehigh Valley, Ryan Stauffer's here, and Ryan, give a wave. Cool. And Mary March, I guess we'll classify you as LVO, right? From Philadelphia, Paul Pasulo's here, without a speaking role this year. Regina Parker, the same, and Regina's here. Regina does a lot of writing, so all in the Pennsylvania-based publication. She's one of their superstars on the workers' compensation world. Wilkes-Barre, Joe Shields is here. Hey, Joe. Pittsburgh, Paul Crooks. We're honored to have him join us this year. I should say Paul Crooks, OBE, if you get the joke. Evan Jenkins, one of the stalwarts. And Kate McLaughlin, who was, no, I was going to make some comment that she was recently married, so that was an epic event. Epic event. A lot of notes in front of me. Other people that are here but will speak at the last program, I won't introduce now. Baltimore, John Hirschberger's here. Jack Huskin's here. Where are you hiding, Jack? Oh, he's hiding outside. Oh, there he is, okay. And I missed Leanne Rhodes from Pittsburgh. Just quick wave. Because it's helpful, I know we don't need each other except in these events once a year. The only thing did I miss anybody? And I'm sorry if I did. Working and helping organize this thing is Tony Mariani that takes a lot of stuff off my desk, and that's been super helpful the last couple of years as he's figured out how this whole thing should piece together. Mark Hamilton, who's from Pittsburgh, does marketing, has arrived and joined the group. The only thing I would say is last year we built a program around impairment rating evaluations with predictions of the speedy work that our General Assembly was going to do to rectify what the Supreme Court had done under the Protz case. Now maybe some of you are involved in legislative committees and are a little more tuned. I'm not, but as far as I'm concerned, it's been crickets from the General Assembly when what we were promised was going to be speedy action to implement some type of impairment rating process again. So you can make your own judgments about how that process plays out. So break time, try to be back in 10 minutes.